Good morning and welcome to today's webinar covering legal indemnities. My name is Lucy Quick and I'm the Digital Marketing Manager here at InfoTrack, and I'm delighted to be joined by Justina Ridley, Harsit Nakarja and Kathryn Graham, Senior Underwriters at Aviva, who'll be taking you through the session today. Good morning to you all. Before we begin the webinar, I would like to draw your attention to the Q&A tab, which is located at the bottom of your screen. We will be running a Q&A at the end of this session, so please type any questions you might have for the Aviva team along with your name into that Q&A box. That way, if we run out of time or we're unable to answer your question, we can take your information and follow up with you directly after the webinar. That's all from me for now. I will now hand you over to our speakers. Thank you very much.
Good morning, everyone. My name is Justina Ridley. I'm one of the senior underwriters here at Aviva. I've been here for about 5 years, and before that, together with Kathryn and Harsit, I was a property lawyer, in my case for some 22 years. So I feel your pain when it comes to the conveyancing grind, and hope that today's presentation will give you a little insight into the world of legal indemnities and how we can help. We're three of a team of 8 who specialise in bespoke underwriting based in London and Norwich. Most of us do have a legal background, although some come from other insurance lines. We tend now to work smartly, so some of us are based at home, some in the office, but we're available by email, telephone, if anyone needs to catch up with us. So today what we're going to do is talk you through some basics of legal indemnities and then look at some case examples. But as an overview, what we're looking at really here is transactional business for property lawyers, dealing both with purchases, sales, refinancing, on the basis of individual transactions or portfolios, and occasionally dealing with lenders for block policies. So if you do happen to have lender clients who are looking to cover a wide variety of properties, that is something that we can cater for. Most of our policies written in perpetuity, so once you've got the policy, it's assignable without needing to come back to us. So that's the generality of our property offering. I'm going to hand over to Harsit, who can talk through some of our specialties.
Hello there. So as well as our legal indemnities in relation to real estate, we also offer legal indemnities in relation to estate distribution. Now, we have a fair few products that are available. I've listed a few there, starting with missing will or discovery of a subsequent new will. That pretty much does what it says on the packet, where we've got estates where the estate itself is an intestate estate, but there is concern that the deceased may have made a will which cannot be found. We also cover unknown missing beneficiaries. This is where they suspect there could be a beneficiary that hasn't come forward or could be entitled to the estate, but actually there is a comfort requirement just in case somebody who hasn't been identified, who's not actually been known, but just in case they come forward. By that token, we also cover known beneficiaries who cannot be traced. And these are parties where there is an element of doubt whether there is an issue or a child or a spouse that wasn't legally divorced. So we also cover situations where there is a known beneficiary but cannot be traced. In Scotland, we also cover bonds of caution. The bond of caution is a coverage that we provide where it basically gives the estate comfort to the point that the person administrating the estate is the correct person administrating the estate and is being administered in accordance with law. The same principle also applies in Northern Ireland, and that's called administration bonds. So we cover both of those as well. We also cover, in both real estate and the estate distribution policies, the option to cover build. which means basically that you can choose a base policy product, whether it's restrictive covenants in the real estate arena with, say, for example, absence of easement. Those covers can be built in together on one policy where the base policy is charged at the regular price, and then the secondary policy will be charged at just another £50 plus IPT. So those policies can be built for a number of risks on one document for one transaction. So likewise, the same can be done for estate distribution products, where you have, say, for example, a concern that the will is missing, as well as the possibility of unknown beneficiaries. You can also apply cover build there.
Okay, I'm going to take you through what we actually cover, which will give some insight into the types of coverage that you may need to come for us for an insurance policy. So basically, we offer insurance for properties based in the UK, and this actually does extend to Jersey, Guernsey, and the Isle of Man. And we can write insurance up to a total limit of indemnity of £150 million. In terms of what our actual appetite is for coverage, no doubt you'll have come across these risks time and out with various transactions, but just to give you a flavour of some of the kind of principal ones we see on a daily basis, we have the classic lack of rights for possibly an existing access or new access ways and services, unknown covenants or known covenants on title, the enforcement of third-party rights, or somewhere they may actually be obstructed, where you don't have enough evidence of land ownership, mines and minerals, or manorial rights, including sporting rights, issues with the planning system, so lack of planning or conservation area consents or building regulations, liabilities for chancel, which is still, you probably see that on a daily basis with risks, leasehold issues where you might have breaches or inadequate provisions with regard to the leases, or alterations where they're not necessarily authorised, and environmental issues, so possibly cleanup costs imposed on a homeowner, where you've had an environmental report with adverse entries, for example. And then we move on to the more bespoke risks, where you possibly are acting for a client who is developing. So there's a change of use. So the risk profile is assessed in a different fashion. Basically, bespoke or technical cover is obtained by coming to us directly through your InfoTrack contact, and we will effectively assess the situation. To do so, we do have certain underwriting requirements, and that is effectively our proposal, which is what we work from. So if you find yourself in a situation where it's not necessarily a straightforward risk and you need some further information assessed, what we really need to develop our underwriting analysis is really what is set out on the page. So what's the development? Have you got planning, or is that to be applied for after the policy is incepted? So we assess that on a post-planning or a pre-planning basis. What are the title risks to the land that is being developed? Is it a restrictive covenant, for example, where it's a new build covenant? Have you any knowledge of who might have the legal right to oppose or object to the development? What may be the consequences for the complainant? Has there been any consultation, possibly on a post-planning basis? Have any parties come forward, objected? What is the actual value of the site when it's built out? So the gross developed value. And that really applies to these types of policies, because one of the ultimate covers for the client will be the loss in market value, the diminution in value. And who needs the cover? Is it the developer client? Is it possibly a plot purchaser or their lender, so on and so forth? So working alongside us, we will assist by asking for the relevant information if it's not provided. Then we can formulate our underwriting review and most likely, hopefully, help you with a solution to move the transaction forward. I'm also going to give you a flavour of some of the other types of cover we have, which principally relate to if you have a client where you have a tenant, for example, or in contrast, the landlord. Often with tenants, the capital value of property is not their concern. It's the lease interest that they're obviously granted if an occupational lease, and the associated costs that impact them. So we have relocation costs as an offering, gross profit for 24 months, and rent payable, and in contrast, rent receivable if a landlord. So really for tenants, this is really quite critical cover, because the principal liabilities for them are being covered with these limits of loss that we can add into the policies for you, and giving them the comfort that should any risk arise and they may have to cease trading for a period, their rent will be covered. Or worse, if it's a catastrophe and they have to cease trading altogether and move, relocation. A further limb that is actually very helpful in a lot of risks, depending whether it's continuous or development, is for service providers, because often they are incurring costs to assist on their development or property if they're connecting cables or whatever. So we can add in service provider extensions, which proves very useful as well. So based off the back of this, I'm going to pass over to Harsit, who's going to discuss the first case study.
Thank you. So we thought it'd be useful to go over a few examples of how we look at matters and the variety of matters that we get to see, and also gives you an insight as to the level of information that we need to assess the matter. So this one, we've got an example for a restrictive covenant. We have a little shop here, which is currently used as a pasty shop. You can see that it's Cornwall Foods. What they wanted to do was turn the pasty shop into a restaurant with the sale of alcohol. And they were concerned that there was a restriction on the title, which basically said that you couldn't serve alcohol from those premises. And it was something that they wanted to cover in terms of the value of the property. You can see the value there, which was just over 3.5 million. And the restrictive covenant was placed on the title in 1952. The restriction was quite straightforward restriction in the sense that it was categorical. There was no mistake in what it actually said, and to the point that it actually pointed out the benefiting land, the Crown Hotel. That does obviously concern people to say, okay, you have a situation where you've got a pasty shop which is down the road from the Crown Hotel that could actually benefit from the restriction. We looked at the surrounding area to see what was taking place. And we also looked at the location of the benefiting land. You can see the actual title that is edged red, and the Crown Pub is marked with a blue cross. It's not too far away, but we took comfort for the fact that it was some distance away, and it's unlikely to know that it has the benefit of the 1950s restriction. We checked the title to the pub, as it's benefiting land noted on there, and they couldn't actually see that the benefit was noted on the title either. But just to be on the safe side, we looked at the title in a bit more detail and also asked the client to see if they could go and get an alcohol license and to see if a benefiting party could come forward to claim the benefit of the restriction. The restriction itself was not actually directly in competition with the pub, because obviously the pub has a different type of clientele that wants to come to the restaurant to have a nice evening meal or an afternoon lunch, which was something that we took into account as well. And ultimately, we offered cover even though we knew where the benefiting title was and it wasn't too far away from the actual site itself.
So I'm going to talk you through a case that I dealt with regarding lack of access easement. So the insured intended to develop this lovely greenfield into a logistics park. But the issue was they had to cross unregistered land, which I've highlighted in yellow, to actually access the site from the adopted highway. So initially looking at this risk, I was aware current use was just to open the fields, and we had a large logistics park proposed. The client wanted to incept the policy before they had planning, simply because that fitted in with their transactional deal. and they needed a developed value covered of 26 million. It's quite a chunky development. And ultimately, as I've said, it was a cover for a lack of a legal right of way over the unregistered land. So in terms of location, having reviewed Google and map search, semi-rural, but there was some nearby industry, so not completely countryside. And we asked for a sim search, which concluded that the yellow land was unregistered, and the site did abut the highway without there being any intervening third-party title. So I was able to see on the plan on the left, which was the highway search, yeah, great, that's adopted road. And then on the right-hand side, you can see where I've highlighted in red the unadopted, unregistered area in question. Helpfully, and this doesn't always happen for ourselves when we're underwriting, the client actually could produce a stat deck confirming that there had been some use of the access areas to the adopted highway with farm machinery over a number of years, which gave some comfort. Now, albeit this was a pre-planning request, we were satisfied, having reviewed all of the facts and making our analysis, that actually there didn't appear to be any third party who could lay claim to the legal title to this area or motivated to deny the developer the right to build the access and then cross it. As such, we were comfortable and we were able to produce a policy to assist the client in this case.
And I thought it would be helpful to give you a slightly more esoteric case study for something that we are asked for quite regularly, but can create a few challenges. So in this situation, as you can see from the picture on the right, we have open land where there are very clear, well-trodden tracks. And the proposer was seeking cover against the possibility that an unknown party might claim a prescriptive rights of way, which could scupper their proposed retail park. Gross developed value of 28 million here, but luckily they had got their planning permission in place, so that gave us something to work with. So, as I say, ordinarily these can be quite challenging rights to cover because we don't know where the claimant is going to come from. It could be ramblers, it could be someone who has an interest in scuppering the development for some other reason. So we do need to do slightly more research in this case than perhaps for others. Now, in this case, what we were able to assess from our research and underwriting was that the site had formerly been a landfill. So that gave us some comfort in establishing that someone coming forward was going to struggle to find 20 years uninterrupted use, bearing in mind that they would have to show that they had been effectively walking through a landfill site for that period of time, whilst the landfill was in operation and whilst it was settling. We could also see that there were roads and other retail units that surrounded the site. And although the tracks were there, in effect, they didn't really have much of a destination other than leading from the main road, ironically, to the McDonald's. So it wasn't beyond the realm of possibility that the McDonald's users would be able to still make their trip using the main roads. Again, a careful assessment of the planning, objections enable us to establish that there had been no objections by dog walkers, ramblers, or anyone else claiming that there were overriding rights that could affect that development. So in this case, we were able to offer a policy, but to ensure that we had a mitigation strategy, what we built in was a requirement that an access be maintained from one side of the site to the other, albeit in a different position than the tracks had been, so that anyone claiming that they needed to get from one side to the other still had the ability to do that. In this case, it wasn't a particularly onerous condition because of the use as a retail park. The proposers were intending, obviously, for members of the public to come onto their site. So those are examples of the type of risks we can cover. Here's what we don't do, you know, as much as we do try and help as far as possible, there are some things that just fall outside our appetite. Now, the most common of these are listed here, and I'm not going to go through all of them, but you'll probably be familiar with the idea of the escalating rents. It's a hot topic. Unfortunately, it's not something that we are able to cover. We haven't really got a mitigation strategy, and obviously it's something that I know is being considered in Parliament at the moment. So that isn't something that we can assist with. Similarly, estate rent charges, modern estate rent charges. Again, there is no mitigation strategy, which is what we're looking for as underwriters. So that falls outside appetite. Company insolvency is something that we have covered in the past, but at the moment, because of the economic constraints, we've taken the view that that is probably something that's outside our risk appetite for now. Similarly, as probably you might expect, things that are relatively recent in terms of changes to properties that don't comply with building regs or planning permission are not going to be easy for us to cover. And similarly, anything to do with flooding and subsidence doesn't fall within our risk strategy, even if it appears as a result of an within the result of an environmental search. So, whilst we're always happy to look at bespoke inquiries, and sometimes there will always be an exception to the rule, that gives you a flavour, I think, of the sort of things that we can't really help with. So that's it in a nutshell. We've tried to just give you a basic understanding of how we try and underwrite risks and what our appetite is. So really over to you in terms of any questions you might have for us.
Thank you so much. If you do have any questions for the Aviva team, please type them into the Q&A box. So we'll just wait a few more moments and see what comes through. Oh, we've actually had one question come through. What do you need when seeking a bespoke policy?
I'll take this one. In terms of, and it might be useful to have the slide. I don't know if you're distributing the slides, Lucy, but what we ultimately need, we can just move back to it, in fact. Okay. Yes, thank you. We want to know what is the development, assuming there is a development. It doesn't have to go into great depths of detail, but to say it's currently a greenfield and we're going to build 100 houses on it. Have you got planning? We will always ask that because we need to underwrite the policy either on a post-planning basis, as in you have got planning, or on a pre-planning basis where you haven't yet applied for it. So a link to the planning portal if you have, a site plan, that's usually very helpful. If, for example, let's take my site to be a housing estate, say you have a lack of an access to that site, let me know if that's going to be access for the entire site or secondary access. What area is it going over? Is it registered to a third party? Have you got a SIM search to send in so we can understand if that land is registered or not? If it is, provide the title and plans to that ownership. That's probably an example for that type of risk. Restricted covenant, if it's referencing a deed and you're able to supply a copy of the deed, that allows us to assess the document in full, because more often than not, an extract on the title doesn't always give the full picture. So we will ask for the deed if that is available, in fact. also key point is what is the value? What is the gross developed value that the client will achieve when they've built out this development? Because ultimately, one of the principal covers of loss is loss of value, which is why it's very important to ensure to an appropriate level so the client is fully protected. And that has a knock-on effect as well. If, using the example of a housing estate, you then will have future plot purchasers and their lenders crawling over the site's title, and you can conveniently pass the benefit of a policy to them. So that's hopefully a flavour as to some of the things you may need. But if in doubt, when you've sent your inquiry, if there's anything else we'll need, we will always sort of prompt and ask for it, so we can work together to get the relevant information.
Lovely, thank you so much. We've had another question come through. Do you offer cover for absence of listed building consent for a UPVC window? We are having trouble getting cover for properties in Cheltenham as there are so many listed buildings and an active heritage department at the local authority.
Shall I take that one?
Yeah.
The answer is it will, I'm afraid, depend on the particular circumstances. I know that's a typical lawyer's answer, so I've reverted back to type there. But for us, the criteria we're really looking for in terms of that is, where are the windows that are changed? Are they visible from the street? Is the new window a like-for-like replacement? How long has it been there? Has there been any contact with the local authority in terms of trying to obtain consent which might have been refused? So it's not an automatic no. I mean, it's more tricky, I think, where, as you say, there's an active local authority or heritage organisation, because often in these cases it's a question of underwriting on the basis of the sleeping dogs lie technique. Yeah, we will always look at them, but it's sometimes a little tricky.
Thank you so much. Do we have any more questions? We've had another one come through. Do you offer cover for absence of management company or management pack in leasehold transactions?
We do have a standard type of policy that covers management situations where the management company isn't answering requirements or is insolvent. And so those circumstances, we can look at the situation where if you have any information as to what the management company did when they were last corresponding. I'm assuming this is for leasehold properties for residential units. And so we tend to look at the background behind that as to what the management company have said. Have they been approached? What's the outstanding information in terms of if they are insolvent or they're just not replying to inquiries? But it is something that we can cover from a management pack perspective on the basis that they are not getting responses from a management company or the management company is no longer around. That is something that we can consider.
Lovely, thank you. Do we have any more questions before we close the webinar? I think that is it for all the questions. I can't see any more that have come through. So I would like to say a big thank you to Justina, Harsit and Kathryn for their time today. We hope you found this session informative. If you've got any other questions about anything you've seen today, or if you wish to know more about ordering an Aviva indemnity policy through the InfoTrack platform, please get in touch with your account manager who'll be able to assist you. Also just want to say to watch this space, as Aviva will shortly be introducing new prices across their entire range of title and search covers, starting from as little as £22.78. All that's left to say is thank you so much for joining us today. Have a lovely rest of your day and a lovely rest of your week. Thank you.